Hi, Assalamualaikum. My name is Siti Nuraisha binti Muhammad Ghazali. My matric number is 061175. Okay, this is our group members. First, it's me, Aisyah. Second, Putri Alia. Third, Najiha. Fourth, Nur Anisa. Fifth, Siti Khatijah. And the last one is Nur Shamimi. Next, our group video assignment have two cases. First, DUBON BERHAD vs WISMA COSWAY Management Corporation in 2020, and second case is the High Court in Coca-Cola Refreshment Malaysia Sdn Bhd vs Legion Capital Sdn Bhd in 2021. My part is introduction for the first case. The first case is about maintenance and service charge owed to Management Corporation are not secured debt. In the recent case of DUBON BERHAD vs WISMA COSWAY Management Corporation in 2020, the Federal Court held the outstanding amounts due to the Management Corporation under Section 77 of the Strata Management Act 2013 is not a secured debt and will not give the Management Corporation lawful preference as a secure creditor over the assets of a company in liquidations, notwithstanding the work guarantee under Section 77 of the Strata Management Act 2013. These are effects. First, the liquidators required the developer to transfer the unit into the company's name to pay off the company's debt. Second, the company denied the claim and negotiation failed. I will pass to the next presenter.
My name is Putri. So the main issue of this case is owed to a management corporation or a joint management are secured or unsecured debts in the context of its solvency. So whether the management corporation's right, the MC, to collect payment from a proprietor under Strata Management Act 2013 gave it a lawful preference as a secured creditor over the assets of a company in liquidation. So these are the facts of this case. The appellant, a company in liquidation, owned a unit in a building. Management by the respondent, the MC. The liquidators required the transfer of the unit into the company's name, but the transfer was refused by Stephens Properties Sdn Bhd, the developer of the building, unless the company obtained a clearance letter from the MC for an outstanding sum. The company denied the claim and negotiations failed and filed a claim seeking an order that Stephens execute the transfer without imposing any fees, and the MC issued the clearance letter upon company's payment of a sum. The MC filed a counterclaim and sought leave to commence or proceed with its counterclaim in the Strata Management Tribunal. The High Court refused the MC's application, but the Court of Appeal reversed the decision, allowing the MC to proceed with the counterclaim. The secondary issue in the case was whether the MC needed leave to recover the debt owed it by the company, or whether it was sufficient to file a proof of debt form in the winding up court. The use of the word guaranteed in the SMA ensured straightforward recovery of the issue that remained was limitation. This issue was not complex and could be solved without adjudication in the court of law. Therefore, there was no exceptional issue in the case that precluded the MC was filing a proof of debt form in the winding up court, and there was no necessity for the grant of leave.
The decision of Federal Court. The Federal Court observed Section 292 of the former Company Act 1975, which is now Section 527 of the Companies Act 2016, and determined that Section 77 does not position the payment of management fees to the level of secured debt. Section 77 use of the term guaranteed suggests that statutory duty between the management corporation and proprietor entitle the management corporation to recover maintenance and other relevant service expenses from the proprietor. The Federal Court explained that Section 77 was intended to statutorily state that failure to pay management fees result in undisputed debt. The phrase guaranteed assures the existence of the debt, and the recovery of debt is certain and may be easily accomplished under the provision. Therefore, the overdue payment owing to the management corporation under Strata Management Act Section 77 is not a secure debt. It is a guaranteed debt in the eyes of the company and the management corporation, and it has no bearing on the right of third-party creditors.
Okay, for the next case is the High Court in Coca-Cola Refreshment, Malaysia Sdn Berhad versus Legion Capital Sdn Berhad in 2021. This case is about creditors voluntary winding up. According to Section 432, the winding up of company may be affected either by way of winding up order by the court or by way of a voluntary winding up. A voluntary winding up may be affected by a resolution, either by a way members voluntary winding up where the company is solvent and the liquidator is appointed by the members at the members meeting, and by a creditor's voluntary winding up where the company is insolvent and the liquidator is appointed by the creditors at the creditors meeting. Based on scenario in this case, Legion Capital only has two creditors, which are Coca-Cola and another individual who is Tan Sri David Chang. Furthermore, the value of debt owed by Legion Capital to Coca-Cola is higher than what was owed to Tan Sri David. So, the appointment of liquidator was successfully challenged by a creditor who is the majority creditors in value but not in number.
Thank you, Anissa. Hello, I am Siti. Next, I will proceed with my part, which is the issue that arises in the case of Coca-Cola Refreshment Malaysia Sdn Berhad versus Legion Capital Sdn Berhad. So in this case, the issue that arises is because there was some disagreement between the plaintiff and also the defendant regarding the appointment of liquidator. So before we proceed, let's take a look the definition of liquidator. Liquidator is a person with legal authority to act on behalf of the company to sell the company asset before the company close in order to generate some cash for a various reason, including for debt repayment. In other words, liquidators are generally assigned to wind up the affairs of companies when it is going to bankrupt. And in this case, both plaintiff and also defendant has their own nominator. As for plaintiff, the nominator is on, and for a defendant is Lim. After go through the minutes of meetings, all parties has agreed to disagree the nomination by the company which is on, even the company shall pass. The nomination by the plaintiff ought to be declined as there was no secondary nomination for ons, also the majority number could not be obtained. Chua cannot be the second nomination for ons as he had received the special proxy from the TSD to vote for the appointment of Lim. As the creditor also said that it might have the conflict of interest between plaintiff and on, that's why plaintiff nominate on as a liquidator. And lastly, the defendant solicited advice the creditor to make an application to the court within the 7 days from the meeting was held. After all the discussion had taken place, it was then resolved that the appointment of Lim as a liquidator is valid.
Okay, let's proceed to the last part of this case, court's decision. Creditor's decision in liquidation governed by majority in value. First, the High Court invalidated the appointment of the liquidator in the creditor's voluntary winding up. With Section 450 using the term nominate, there must be a nomination at the creditor's meeting. Other than that, when Coca-Cola's application was filed against the company, it's not clear whether permission had first been obtained to allow for the filing of such a nomination against the company. Further, on the issue of Section 521(2), overriding the requirement in Rule 119. Rule 119 applies to court for winding up matters and creditors voluntary winding up. The rule also do not provide for a situation in which there can never be a majority in number voting since the company only has two creditors. Lastly, the court also applied the case of QB Khidmat Teguh Sdn Berhad versus Pembinaan Legenda Unggul in 2017. In this case, Muhammad Nazlan JC was aware of the need under Rule 119 for there to be a majority in value and number of the creditors. and he commented at the creditors meeting about the voting being based on the value of creditors' claims. Okay, the court also made the conclusion against the conduct of creditors meeting. First, the court commented that Tan Sri David Cheng was not only a related party but also a creditor of the company. This will lead the court to the inescapable conclusion that Tan Sri David Cheng is an interested party in ensuring that the choice of the company's member, that is, the first liquidator candidate will be voted to be liquidator of the company. Next, the court held that no legal authority was put forward that required a seconder in any meeting for a proposal to be carried through or vote on. Based on the fact of this case, it will be unfair for the company to insist on their being a seconder. That's all from us. We are highly thankful for your time and attention. We hope you find helpful information here and use our video as a guide for your learning. Thank you.